for those up on the session that we had yesterday, dealing with issues that public defense or defense counsel may encounter in terms of representing defendants who have had some drug involvement and cognitive or mental health impairments potentially. We're going to follow up now with, I'm going to turn it over to Genevieve, who's going to introduce a few questions that came up, and we'll also address two scenarios that we discussed briefly yesterday and a few other issues. So Genevieve, you want to...
Yeah, thank you very much. And thank you everyone for joining in. We have a small group here today. There's 6 people who are in attendance, so we really encourage you to participate either through the Q&A or by raising your hand. We want this to be helpful for you, and we want this to be as interactive as possible. So with that, I'm going to turn to the first comment and question that we received. It does not look like the person who submitted the question is online. So Yvonne, I'll turn this to you after I introduce the question. We received this from a Chief Assistant Public Defender in Broome County, New York. The defense counsel said, I've represented numerous clients in our local drug court. When a client is alleged to violate a term or condition of the drug court contract, he then must make a presentation to drug court team for a statement. Thereafter, the team meets to consider the client's state. So the client is excluded from this process. Objection. I agree that whether the client remains or is discharged from the program is certainly a critical stage of the proceeding and thus subject to the right to counsel. I've also said we're having counsel present in the best practices. Has anyone also experienced this, and what are your thoughts on the right to counsel argument? So with that, Yvonne, who is the team not listed in the question? But so for the first stab, I'd like to assume that it's just the treatment and the individual who are part of this conversation. So Yvonne, what would you do and how would you respond?
Hi, good afternoon. Can you hear me?
Hear you. We can all hear you, Yvonne.
Okay, great. Thank you. Just was checking. First, this was a troubling question. There are several questions. Unfortunately, the person I think who wrote the question isn't able to answer some questions that I had from the beginning. I was curious as to who's present in the room. First instincts are, if the judge is present, if the tutor is present, there certainly should be no reason why counsel shouldn't be present. And it would seem to me to be a constitutional violation. And the right to counsel has been denied at a critical stage, particularly if this is at a stage where the person is about to be ejected from the program and that there are liberty interests at stake. It is a critical stage. I don't think I'm befuddled why the court would take that posture. On hand, if the quality meeting and the only person present is, let's say, treatment and a probation person, or usually it would probably be the probation officer or supervision person, maybe the treatment provider and or the program director. If this is an opportunity for them to try to get some information from the client as to their motivations, are they committed to the program, if they're going to if there have been violations and the nature of those violations as to whether or not to continue them into the program, and then to make, quote, a recommendation to the public defender or defense counsel. That might be a little different. But this New York State, New York County Court, so that'll be my initial reaction. And I think we have somebody on the line who's able to give us some insight from New York. Marty Crawford.
I think Marty's comment was that she's from the New York Defenders Association, and we'll talk to the person later today who asked this question.
Great.
I mean, my thing is, I agree with Yvonne totally. If the judge is involved in any way, it's a critical stage, period. And the lawyer has an absolute right to be there, and that's been the law since, for judge says right to be there, then I think is definitely something, again, that it's worthy of an interlocutory appeal. I tell you that in my days representing patients at forensic psychiatric hospitals, there were many times that I asked to be at staffing. I didn't have at that point in time a constitutional right to be there. In other words, the U.S. Supreme Court has said a patient at a staffing with forensic patient has an absolute right to counsel. I knew that, but I asked anyway. And generally, I was granted that right, not all the time, but asking that question, I found the courts took me seriously. They knew that I was going to be there representing my client as vigorously as I could. So that was a lose. I mean, it happened. But I think it's worth raising the issue to let the judge know that you believe this is very, very serious. Certainly, if the DA is there, I don't know whether you said that or not, I didn't hear that. If the DA is there, then that creates a terrible power imbalance, and then is worthy of an interlocutory appeal. If the local county rules are the DA can be there and the defender can't.
I would agree. I also would like to just back up a little bit. I think that this is an opportunity for us to look at other aspects of programs to see what kinds of or agreements are signed with the from that court has conducted from the beginning. Are people aware of what the program involves and what kinds of things will be taking place? Certainly, defenders should try to construct their agreements and their program rules so that those types of situations would never take place. So there's a structural aspect that is a part of the planning and implementation aspect of the court, or at least maybe it's something that you have to take back to your team, your public interest entities and offices to ensure that those types of hearings don't take place. That client is never in a compromising position that could be confrontational, and/or their due process rights are also at stake. So this, I think it's pretty safe to say, is a very poor situation for clients, and as I said earlier, is amount to a constitutional violation. The other issue that I am concerned about is whether there's a record being made, and I would assume that there is not a record. These people are in a private room, in a behind closed doors. There's probably not a recording taking place of what is happening. There's no record. That is also, I was glad to read that the defender at least make an objection, and I hope that those objections are made and placed on the record, because if something does occur down the road, the appellate lawyers don't have basis. There's no record to appeal on if there's not been a record made. So that would be the other issue that I want to address.
Great. Let me ask a follow-up to that. So you mentioned a little bit about kind of the team spirit, adversarial nature of drug court, and how do those two kind of play off each other, both in this setting and also just in general in the drug court setting, and what is the role of defense counsel in that, in the team spirit versus kind of being the adversarial?
Mm-hmm. Well, I'm very clear about what I believe is adversarial. There is no such thing as always advocacy that is taking place, and that is the counsel's role. You don't do away. You write off your obligation, your ethical duty, your responsibility to advocate for your client all the way through drug court at all stages. So your team might need to understand that in team spirit, you can be part of the team, and you can be, that you can have that team spirit, but they need to understand very clearly that you have to advocate for your client. Prosecutors never stop advocating for public safety, and nobody has an issue with that. Counsel must always advocate for their client, and that doesn't mean that you have to do it. And the way to be non-adversarial and how you do it. you go to sidebar. You might address things after one has cleared the courtroom and it's other participants who are usually in the galley who are watching the activities of the drug court place, and everyone else is dismissed. I go back on the record and have that pointed objection made on the record on behalf of your client. That way you're not interfering with the therapeutic jurisprudence or that therapeutic aspect of things during the drug court. So I think there are ways to handle it. You don't have to be a spoiler simply because you advocate for your clients, and attorneys have to be very clear of that. You're advocating, you have an ethical duty, an ethical responsibility, and an obligation to advocate at all times. And how you do it is, I think, the key. Understanding that advocate in a non-adversarial setting is a nuance, but I think it can be done.
Thank you. And Michael, do you have anything to add to that?
Not only one kind of comparable note, and I say that with a smile. I was fortunate enough this last summer to go to New Zealand and do some work there. And as part of my work, I observed drug courts for 2 weeks. An extraordinary experience, and I actually have blogged about this therapeutic jurisprudence blog run by Holly Spencer, who is a magistrate in New Zealand, and she's Australia rather, in New Zealand. And the defense counsel was at all of these staffing, and the defense counsel certainly provided precisely the level of advocacy that Yvonne just so beautifully articulated, but having the defense counsel there gave more legitimacy and more likely that a defendant was going to go through whatever the final issues were. The defendant knew that she was being represented. And what about this? I said, I saw more due process 2 weeks in New Zealand than the exception of 3 or 4 judges I've seen 4 years in America.
Well, I must say, let me just add that, Michael. I must really glad to hear you say that, because it was the judge, myself, and a few from NADCP. We were the team that trained the New Zealand judges in Auckland on how to set up their drug courts. So they get that model from us. And overwhelmingly,
I did not set this up ahead of time. I didn't know that until a minute ago.
That's why I'm saying I'm glad to hear it. So I believe that the model that Auckland, New Zealand, the judges there, that they adopted our model. And so I think that I'm glad to hear it's going well in New Zealand, because I haven't talked to the judge in a while. But I think that for the most part, as we train our attorneys here, they learn that. I would like to just shift back to our scenario. I mean, the question that came in, because I did have questions that the person not include in their job, which was whether or not this person suffering from a mental health disorder. I think that raises additional questions when the client is cognitively impaired or has mental health disorders. With that kind of a situation, when you're putting them into a very stressful environment, it's like going before a jury, standing up in front of a crowd, and you have to explain yourself. It's just very stressful. Number one, people are expected to articulate how they're feeling. I'm not sure. It's not sure about that, and I would like maybe we can follow up with somebody on the mental health side or a therapeutic on the side as a psychologist or somebody who understands that particular component, because I'm sure that that's a best practice.
Great. So Yvonne, what would you do?
I just wanted to add that scenario was so disturbing to me, because we visit hundreds of programs, and one of our themes is that, first of all, when a person is not in noncompliance, it is a therapeutic response, not a punitive one. So as Yvonne was well articulating, that where is the program looking at? Why was this program in a non-compliance? Was it willful, or was it tied to their addiction, mental health, trauma, who knows what the background was? So that's number one. But number two, the process for the program needs to be transparent, consistent, and objective. So the presentation, what does the presentation entail, and then what does the team do with it? Is there any rational basis for their decisions? I think one of the problems that we're finding, and this is where public defenders or defense counsel are so important, to keep these programs on the up and up. It's just not that everything goes because you're in a drug court and all the rules of procedure just evaporate. So I think a major role for the defense, and as Jan said, sometimes if the program is going to, and we've seen this, employ practices that are not constitutionally defensible, sometimes you just have to say, well, this is just not a program that we can support. And we've seen this is where, unfortunately, defendants who need to have the benefit of the program really can't be recommended for it. So I just wanted to add that.
I would add one other thing, Carolyn, before you go on, Genevieve, is that in situations, counsel also has to have the support of their offices if they happen to be part of an institutional public defender organization.
Absolutely.
Because the individual attorney who's in court, who's fighting the fight, who's in trenches every day, if they have to go back and battle, they need to know that their bosses, their offices, the appellate departments that support them are there and will support them. They have to file an interlocutory, because that kind of goes against the grain. If you start filing motions, they think you're not a team player. But if you feel if you believe that your rights are being violated, then you have to do what you have to do. There's a difference between fighting a cause and fighting for your client. And it's not about, if it's for the cause, you can't fly under the bus because you want to stand for a cause. If it's affecting the client, you represent the client, and if it's for that client, you have to represent your client and protect your client at all instances. And you need your office's support or the organization's support. I must say that if it's a little different, if a lot of times that I've seen, and I've traveled around the country, that if you're an attorney and you're in a contracted position, it's a little hard to kind of kick dirt in the face of, the person who has your contract. And that is a real dilemma. There, I would ask that maybe the attorneys who are in that situation seek support from the private bar that can give them support, or their local criminal defense association that might be able to assume in that regard.
Yeah, I think that's absolutely right. Now, I was thinking, actually, I have two things I can add to this. Number one, I was in, as I think I mentioned yesterday, I spoke in Austin, Texas last month to the National Association of Criminal Defense Lawyers, and I was elated that about a third or 40% of the people there were public defenders. I thought it was going to be private counsel, but they gave scholarships so that the PDs could be there. And it occurred to me there is so much, they've got such great resources that could be worked with, number one, or the National Legal Aid and Defender Association. I want to go back to one thing a little before when you're talking about therapeutic jurisprudence. Principles of therapeutic jurisprudence include and I hope that one of the other two webinars in this program we're going to be able to talk about this at some length, because I think this is extraordinarily important. Include voice, validation, voluntariness, and sense of dignity. I mean, TJ, you put it up, post-it, that's what you've got. Voice, validation, voluntariness, in the context of dignity, with the assumption that there is an absolute right to counsel. If someone feels that decisions are being made behind his back, with him, with his representative, leaving him in the dark, he will not be validated. He loses his voice. He will not feel as if it is a voluntary situation. He will feel no dignity. So that problem-solving courts were created in the image of therapeutic jurisprudence, but to exclude in inappropriate ways individuals and or their representatives from the most critical aspect of the gig strikes me as being completely contrary to that. And I think that's another important point to make.
I'd like to open it up and see if there's anyone on the line who would like to contribute to the conversation or who has any follow-up questions for that. So as Mika mentioned earlier, if you'd like to participate by phone, if you just want to raise your hand, or if you have any other comments or questions to follow up, please use the Q&A. So let's just pause for a minute to see if there's anybody that would jump into this conversation.
Might 14 other participants, so hopefully someone has something to say. Or not.
All right, so it doesn't look like anyone would like to join into that, so I think we should just go ahead and let's go back to this presented yesterday. So the first scenario is Mary. I'm just quickly going to give a little recap, and then I'll turn it over to you, Michael and Yvonne, to kind of help us unpack this situation a little bit. So recall Mary's a 32-year-old single mother. She's a full-time fast food worker in the job. She has one prior arrest and one prior conviction. On the same question, she left two children at home. They're 11 and 7 as she went off to work. When she was home, she was stopped because of an inspection sticker. During the stop, her record was checked and it revealed that she had an outstanding bench warrant for a DUI. She said she didn't know that there was a warrant, and she now has a new address. She was arrested, and while she was arrested, she was found to be in possession of pills without a prescription. She was arrested for possession of CDs and possession with intent to distribute. She had 60 pills of OxyContin on her and endangering the welfare of her children. Her children then placed in foster care. Mary states that she is depressed and was once diagnosed with clinical depression. She's been evaluated. It reveals a positive urine screen for opiates, and she is placed in the drug court program. In the first 2 weeks, the probation officer indicates that Mary often comes late for her early morning urine drop. Because of this, she's now considered a positive test and now has a curfew. She's missed some AA meetings that happen at night. So she's fine, but a little bit depressed. Her behavior is a little inconsistent. So she's not sad, but she's anxious to get her kids back. She said she doesn't need to talk to people and she doesn't trust the system. The problem, we need to determine the true source of her resistance and recognize that Mary may be steeped in a deep depression, and we will help her. So the question is, how can you, as a public defender, or as defense counsel, help Mary recognize that she may need clinical help? That there may be more to this than just not wanting to participate in her lack of trust in the system. So Yvonne, I'm going to turn to you first. How do you deal with this situation?
Well, I think that if you can go back to the first slide, scenario. I don't know if that's, well, there you go. I mean, the first thing that we have to think our clients, and the reason that they're even engaged in this criminal justice system, is that they're facing criminal charges. The first issue that our obligation is to help her with is to figure out how we can assist her with the charges she has present. Of course, we back up and say, well, gee, of course, this conversation comes in the context of a drug court, but a regular court or a court, you have to make the decision depending on the structure of your drug court. Is drug court the best place for her, right? Right from the beginning, whether or not this is somebody who is going to benefit from a drug court environment or going to hinder their success. Is it somebody who would normally do well in the program, or maybe not? Look, depending on your drug court program, if it's progressive and you have a lot of resources, it may be a great place for her because she can get a lot of support, resources, mental health counseling, and or other support that she may or may not get in the regular probatory track. What is guilty of? It looks like if she has prior for CDS and a prior for DUI, she has a prior arrest, not a conviction. So we know that she has a prior DUI still out there, but clearly this is somebody who has some underlying substance issues that are continuing to cause the chaos in their lives, and you'd have to deal with the criminal justice issue. If the program is a felony, if she ends up being felony charges, which she may very well do because she's got possession of 60 pills and she has no prescription and she already has a prior DUI, which is already open and she's bench warranted it. This is a person who takes situations, and this could be attached to other things, poverty, lack of health care, all those things that confluence of issues that put them to this situation where they're dealing with other complications in their life, but it's coming up in the criminal justice world. So we go from here. Go ahead.
Okay, great. Michael, do you have anything else to add on that point?
A couple of things. I think you're totally right. I mean, what's the most important thing to Mary right now? I think the most important thing to Mary is not to lose custody of her kids. The kids are in foster care. She wants to get her kids back. And as her lawyer, you sit down and have a heart-to-heart with her and say, look, as long as there's some questions you may in fact have, expression, that's serious illness, you're not going to get your kids back until you voluntarily go for help. You know, this has absolutely nothing to do with her criminal charge. This has nothing to do with the core role of the drug court, but it's what Mary wants.
But remember, Mary is charged with endangering the welfare of her children. She loses her kids, termination of parental rights. I would agree. I agree with you. But the first thing I would do is try to get her children out of foster care in the hands of somebody in her family or somebody she knows. That might reduce.
Right. She's going to need a lawyer for that. Now, someone yesterday pointed out that her husband does both child care cases and drug court.
Yes, in our office, in my old office, we would, the same criminal defense attorney, that our office handles the endangering charges as well as the drug court and criminal charge. So if you have a great drug court, you could negotiate a plea that would drop, of course, the endangering charge in exchange for her getting clean and sober and getting her children back. That's the best outcome. The endangering charge, in our jurisdictions, you're facing 2 years if you're ever convicted of it. We know this was a mom who was out working, and she left an 11- and 7-year-old home alone. Nothing happened, but they were home alone. So something happened, and that's the problem. So this is a situation where you could enter into a plea, if that's an appropriate outcome, where you would dismiss the endangering charges. They would get dropped, which would be a great outcome. You get your kids back, and you get this person to understand the importance of assistance with their mental health, and we know that there's mental health underlying conditions, so we need them to get control of their drug use, the substance use, and she does the proper assessment, would be the mental health assessment, and she's given indications that she's been previously diagnosed. You need to get a full workup to show that if she does still have some continuing mental health disorder, that those issues are also addressed. That would reduce the risk that her children will ever be in danger again, and she may not reaffect. Also, we see that she's not using her UAs have come up dirty, so at least it looks like she may be trying to, abstain, but she may need assistance in dealing with her mental health disorder. That would be, if you have the proper drug court team and plan in place, if they handle those cases, that would be good. Reading a comment here, so I got distracted.
Yeah, great. Let me I'll read the comment. We have a question that has come in. Yvonne, I'll let you address it first, and then Michael will turn to you and let you add. How to get Mary to trust her lawyer enough to have those conversations and make those decisions? These are personal and, deep concern, Mary, and so how do we get her to open up?
Oh,
great question. Thank you.
I think that the first is to talk to Mary confidently. You have to go to her. It can't be holding cell outside of the judge's chambers. You have to go meet Mary where she is if she's in custody, and she may very well be. You have to talk with her about what she needs. What she wants to talk to you about the first time probably has nothing to do with her criminal charges. It has to do with her children back. And the way you can establish that is to ask her, who can talk to Mary? Who is that can help us? What friends do you have? Is there anybody who can help take care of your children? What information can you tell us about? You have to, really get to believe and hopefully convey to her that you're there for her. And you can tell her about the possible things that will, you can give her the vision that she can get her children back, that she can get the chaos to stop, that she can, get empowered again if she can provide those resources that will help her. And by telling her the kinds of things that you can, you should be totally familiar with the program so that you know which of the programs in your community work with women and children, women and families. And how do we keep her from losing her apartment? She's worried about if her rent's going to get paid. Is going to lose the part that she just got, which is why she didn't get the notice from the first DUI. So I think that really what the question is, how you get Mary to trust her is to communicate with Mary and to talk with her about the things that are important to her, and then try to see what you can do to schedule meetings as quickly as possible in court, and maybe get some feedback on what's happening with her children so that Mary can begin to understand that you are the way that can help. You are her key to getting out, and that's what she needs.
Now, Michael, do you have any other comments to add to that? Go ahead.
I agree with everything Yvonne said. I think, Marty, that's an absolutely terrific question. One of the things, there's so much going on here. Right. From the very beginning, the lawyer has to establish a relationship with Mary, that the lawyer is the person she can trust. And I understand, having done this for so many years, why there's an inherent distrust of the lawyer. The lawyer often has to work very hard to overcome that. Let Mary know that the lawyer is there for her and present her interest. It will be the lawyer's judgment. It will be what the client wants, to make that clear. And once the lawyer gains her trust, there's all sorts of stuff, Marty, that is written about client-centered counseling. And I don't know if you've ever read any of that. The kind of thing that sometimes you'll have maybe in a clinic in local, and then it goes by the wayside once you're in the actual process of representing people. But active listening. And if you want to send me an email later, I can send you some sites or some things to read that would be of interest. It really, in my experience, works. It does. And of course, what Fred Yvonne said 2 conversations ago, requires that we maybe get the EDW charge rough. What that requires, and I can't even, I need to know who the judge is. What's the judge like? Does the judge take these cases seriously? Why is the judge on the drug court? The judge on the drug court because the judge really thinks he or she is going to be able to do better for the people whose cases come before him. He's there for some other reason. If you've got a judge who really takes this job seriously, not who really, to whom the clients really matter, then I think that maybe you kind of work out this deal. But we go back to the first question, which is, I think as a lawyer, you really have to be very, very convincing with Mary that if in fact she does seek help, her chances of getting the kids back, of getting that charge eventually drop, are much greater than if she doesn't. But having said that, I want Mary to be seen by somebody. I'm not a therapist. I said Joe yesterday, I just played on television. I'm a therapist. I want Mary to see somebody. I don't know where Broome County, I apologize. I don't know where Mary is. I don't know whether or not there is a medical school, a psychology department, a social work school there somewhere. But for me to see somebody with some professional training, someone who could be an expert witness, it's not they're going to be testifying in court, to you a little bit of backup and to let Mary see that there's stuff going on here that maybe Mary herself doesn't recognize. Because it's like a domino effect. Once Mary sees that, and once Mary is willing to get some help, then I think the judge may be looking at Mary very differently. Because some of these things about Mary could be interpreted either way. She shouldn't come to the meeting. Well, it could be because she's out getting high, or it could be because she's working her butt off at 2 jobs. She got home at 5 o'clock in the morning from cleaning a department store all night. We don't know that. But a good lawyer, if in fact Mary had that kind of stuff in her back, then what she's doing will be able to make that argument persuasively.
Great. Thank you both so much. I think if anybody has any other comments about this scenario, please voice them now. Otherwise, I think if we have 20 minutes left, we should turn to scenario 2.
How much more, by the way? I'm still working. I'm going to have a job in 5 minutes.
I did want to say one more thing about Mary, Genevieve, is that I probably neglected to say. I want to know if Mary at any point was on medication. The fact that she may be self-medicating for her depression, and that might be because she doesn't have access to health care or she doesn't have access to doctors, and so she's getting street drugs to help her with her depression. So I'd like to know that. I'd also make, requests for, authorizations of any previous treatment she's had so we can get her medical records. In addition, one other thing, and this may be, and it may vary from office to office, county to county, state to state, whether you have a state public defender system or whether you're part of a public defender system, because who controls your purse strings on getting expert and outside referrals for doctors? So the public defender is able and has control over what they authorize expert use. So if my client to be seen by a psychologist to determine whether or not she has an underlying mental health condition, I could just send ask my doctor on call. We could approve expert request, and my attorney, I would authorize it and send the person out, and they would go visit my client in jail or wherever they're at, or they could go see them. Now, sometimes those doctors are controlled by the court, and you have to actually apply to the court and approval to your client seen by a medical professional. And sometimes the courts deny those approvals. So that's very troubling to me. That happens, and I have seen it happen a lot. So that is just another dilemma. Now, if that is the case, and your jurisdictions are very, tight about, releasing the strings that would allow you to hire a doctor or a psychologist or a therapist to see your client, I would then say to your organization or to your offices to see if you can develop relationships with local universities, hospitals, teaching hospitals, especially if you're near a teaching hospital, or universities that might have SW programs or PhD candidates that can work with you, and sometimes they do it pro bono. Or, every now and then, if your office uses a particular pro bono, expert, see if you can get some pro bono dollars and see if you can get those services provided to your office for your clients.
Great.
Lawyer, the one you're talking about that. In 1985, the Supreme Court decided a case called Ake versus Oklahoma that said if a person is indigent, he has an absolute right to an independent psychiatric help if he's proffering an insanity defense. And it has been very, very penurious in expanding Ake. And it has always puzzled me why the public defender offices are not more in the forefront, going to their own state Supreme Courts and where appropriate to the Federal Circuit Court. See Ake expanded to have the state compel the state to provide independent assistance in a variety of cases beyond simply the insanity defense. It's such a minimal number of cases anyway. And anybody who is in any kind of statewide organization, and some of you are, from the information that Monica gave us yesterday, I think this is as important of a case that public defenders can try to focus on. Get the courts to expand the ways that defense lawyers can get paid for assistance, a variety of cases beyond what the Supreme Court ordered 30 years ago.
Great. Let's turn now to scenario 2, Juan, and thank you both for those comments. They were very helpful. Someone who's 26 does not have a full-time job. He has 2 prior convictions and currently a backseat passenger in a car. There's another passenger in the car. And they're stopped at midnight for speeding. The plates are on and it's determined the car is stolen. All 3 occupants are ordered out of the car. A search incident to arrest reveals that there's cocaine under the front seat of the passenger's side. Juan's knowledge of the stolen car and possession of the drug. The police report indicates that Juan is under the influence at the time of the incident. All 3 offenders are arrested for possession of CDS and receiving stolen property. Juan offered a deal. He's allowed to enter a post-adjudication drug court as a condition of probation. And upon successful completion of the program, his conviction will be expunged. Question, how would this response be different depending on whether expungement was part of the process or not? So I'm just going to pause here for a moment, think about that, and then we'll address that in our discussion. So now assume that he goes forward, he enters the post-adjudication drug court. Most of the time, the probation officer claims he is not motivated. While not completing his workbooks, which required by treatment. He work and program wants him to focus on treatment. He's diagnosed with bipolar disorder. So Juan doesn't want to take his medication and he wants to feel quote unquote normal. But if Juan doesn't take his medication, the program requires that he's terminated. To deal with this situation, and what would you do? So let's turn to you first, and then Michael, I'll go to you.
Oh, I get all the hard questions. Let's go back to the first of the slide. I can kind of start from the top.
Sure.
It's shut in my voice. I had this voice yesterday, so I apologize. Of our client who's unemployed, clearly from the top, you even think is a good defense attorney, the guy had a shot at defending the case, right? Not 2 priors, theft, but changed his ways. He's 26 now. Let's assume it happened when he was young. There's a possibility that this kid have a defense, albeit at a steep amount of climb, but might be able to defend himself in a case like this. If he was a passenger and the driver, he doesn't own the car, but tough cases. But let's assume that my client is like a lot of my clients who doesn't want to deal with the stresses of going to trial. They don't want to risk a chance of getting convicted. They've got 2 convictions already. They know they might be facing a 3 strikes or recidivist extended term rather, because now it's a 3 felony conviction. And so there's a good likelihood that this kid would take a plea, particularly since he was under the influence. Let's assume that happens. But I think Molly's out there would probably agree with me. Just say yes if you would. You agree. But then dealing with, if that's the case, and this opportunity presents itself, that he'd get an expungement out of this, that would be really good. A guy like him, some people, it doesn't matter because he already has 2 prior convictions. But to me, it always matters. So if you can get an expunged, I would go for that. And you can get him treatment. And if he can get out of the program with success, who are we looking at? We're looking at kids that has a CS, substance use disorder. I would think that would probably happen. Can we just go to the next slide? I don't remember. The influence. He substance use disorder. And one is we lose other factors. Angry, that Juan is angry a lot of the time. He's reading his workbooks. He doesn't want to go to work. Maybe there's a cognitive problem here. Maybe he's there might literacy issues. Why isn't he getting jobs? Why is he angry? Well, if you can't get a job, you've got a right to be angry, not right, but, certainly I think a lot of people, I understand why you're pissed off if you can't get a job and if you're not working, no matter how hard you try. But if you keep looking for jobs and you're not getting the job because it can't complete a workbook in treatment, you may not be able to fill out a job application. So there may be some underlying cognitive disability that hasn't been identified or tapped into. So I'd like to have him assessed, and I would like to have a full-blown, again, I would go for a cognitive or mental health assessment to find out what is going on with my client. He doesn't want to take medication. He wants to feel normal. But we also know, if we're on the call yesterday, you heard Michael talk about the onset of certain disabilities and certain, whether cognitive or mental health. We know that particularly some young people and boys may be onset with, things like bipolar that happen a little bit, maybe around this age, a little bit younger. Young people don't, a lot of times will say, and anybody who's been in the juvenile drug court, just don't like to take drugs to be normal. And so it's not unusual. So there may be something going on with him mental health-wise, so need to get an assessment and understand why he doesn't want to take his medication, but also try to assess by somebody that can tell him that may be why it is good to take medication. Or there may be some cultural lenses we have to look through. I don't know Juan's background or ethnicity or community he's from, but I do know that from certain communities, taking medications 2 weeks, go to a psychiatrist is really a big way to spend your money. Who go talk to somebody? That's like dumb community when you're trying to pay rent. I pay money to go see somebody. So there may be some cultural issues here, why this person hasn't seen a professional in the past. Also, there may be some reason why this person, if they haven't completed an education, dropped out of school, and we didn't get that information, educational educational assistance early on in their youth when they were in school. So I'd like to know if he's ever been in a special ed program, or not they fit high school. And all of that kind of as a workup to get to whether or not one would do well in a drug court environment or not, and not, and we can exclude. I'd like to either exclude that doesn't have a mental health disorder or a cognitive disability. So the idea to do that is to have him assessed and let the professionals tell me what he does and he doesn't. And from that point on, I would have to decide what to do next.
Well, Michael, what would you do?
Well, it's interesting. I think Yvonne is absolutely right. But I have another thing I'm going to throw in that's going to conclude what he up to work. And it's important that I raise this. And it's a great extent of my raising this now is informed not so partially by being a public, but much more by all the years I spent representing people with mental disabilities. What medication does the program want Juan to take? Who prescribed that medication? What kind of screening was done prior to Juan being prescribed that medication? I've been in situations where medication was prescribed without any real study of the subject of it to find out what he may be susceptible to. Some medications are toxic. They're toxic for me and not for you. You do that, and you can't determine that unless you do some pretty sophisticated testing. I have no reason to believe that this thing is being done in Juan's situation. So I know why doesn't Juan want to take the medication? And we learned, and I represented thousands of people in cases involving the right to refuse medication. Some of the reasons were kind of bizarre, but simply, I just took that pill and made me a little sicker. Here's another pill. We know there's usually not an array of medications. There is one drug, and that's it. And that's problematic. There are cases in virtually every jurisdiction on the right of people, a qualified right, albeit, to refuse medication. There's nothing that I know of in drug court about someone who's like one, whether he does or does not have a right to receive the medication that is being offered to him. This may be the issue, but I have to use my moment here to talk about it because I think this is very, very important. And as his lawyer, have to understand that this is a legitimate issue. Generally, if my client wanted to refuse medication, my question would be, what else can he get? And very often, in another medication, he took that and things worked well. But nothing from this scenario that tells us that he wants to feel normal. Maybe the medication that he is being prescribed for him, he's in the past, and he would feel a lot crazier. We don't know that. So I think we need to talk to somebody about it. And again, just as I said in the last scenario, that we need to be able to consult with people who are maybe psychologists or social workers, here I'd want to consult with a psychopharmacologist to find out whether or not the medication that's being prescribed for him is going to make him feel the same, better, or worse. In fact, it's simply he doesn't want to take it because he's macho and real guys don't take medication. Then I think what you do is you go back to just what Yvonne said in terms of counseling Mary. Whether or not he's bipolar, I think the kids are very well. You understand what you were saying and say, look, if you don't take this medication, if you know constitutionally based objections to it, if you take this medication, you're going to get drug court and you're in prison, maybe you'll get that.
Michael, you said an interesting little thing there. You said, well, if he thinks he's macho, therefore doesn't take the medication. I just want people to understand that is that thin veiled cultural piece that we sometimes miss. That macho really means that in the view of my community, I'm and so they don't really. It's not about being macho more than it's a weakness if you can't handle your own mentality on your own. And so it's a lack of education and also a lack of acceptance. So sometimes it also we might also want to encourage the person to bring their family member as support, as part of their family, their circle of support that helps them make decisions that are best for them. They will. If their mom is with them or somebody, a 26-year-old will bring his mom. As by the way, as a mother of a 26-year-old, I do know they still call us for stuff, right? And so I'm chuckling out there. I hope you're chuckling. You still do reach out to people, no matter how old you are, as a part of your support. So I hope that would. They have to always remember to reach out to try to get the support. Client in those people around him.
I want to
Great.
We know one big conviction twice. We don't know if he's been in jail. But either way, if he were there and he saw the way medication is distributed in jails and prisons, and everybody knows what everybody is getting, he would know that people getting psychiatric medication are going to be looked down on, are going to be laid down in a pecking order from other prisoners. And
well, that is that's the point, Michael. That's the culture of the culture within prisons and institutions, right? One, it's a mistake to take the medicine of the jail.
Right.
So it's like you're a punk. So you don't take your meds, right? Some people are put into a special ward and they're isolated and they may be taking it, but it depends on what's happening. So it's also important for defense attorneys to, when they carry with you all the time. I always say, carry with you a blank authorization for release of medical information so that you can get your client to sign it, even if they won't tell you or they may not know what they're getting. They'll say, oh, I'm getting something in the jail, but they have no clue what jail is giving to them. Have them sign a release for authorization for that information so that you can then send it to the jail to find out what kind of medication your client's been given.
And literally has a tranquilizing effect. So many inmates have to be on hyper alert all the time to be wary of predators and know this. And let's assume that one is gay in a jail or in a jail where gay inmates are preyed upon by other inmates. It's like a very rational decision that he makes not to take medication. It's just how to think about it.
Well, thank you both so much. It is now 1:30, so we have run out of time. And thank you, everybody, for participating and attending this webinar. It's being recorded, and we will send out a recording later on.
One recommendation, Genevieve, before I go.
Sure, absolutely.
To the participants, the attendees who are out there, I think it's really important if you would go to your local statistics from jail, local county jail, and find out should be able to get that from the county jail. What numbers or percentages of your populations are being given medication in jail, just so that you kind of know what's happening in your own local jurisdictions. You know that some of those statistics are available to the Department of Justice, and we've seen some of those statistics, but you may be able to get them locally. And we'd appreciate any feedback from you or any questions that you have that we've answered, or is there anything that we can do that would help you in a more concrete way to assist you as you kind of struggle through and figure out some of these dilemmas in your own jurisdictions. Thanks for having us.
I wanted to add that this is the first of a series of 3 interactive web meetings that we're going to have dealing with issues relating to public defense and representation of participants. So we'll be sending out the notice for the next one, which I believe is April 4th, is it?
Yes. April 5th.
If
anybody out there has model motions and filings of things that they've done, we'd like to receive them. You can send them to Carolyn Cooper at American U, because we are trying to put together model templates for be able to file motions to advocate on behalf of your clients and to good database of those kinds of documents on file.
And also, if you have any scenarios like the one from Broome County that you'd like to have discussed at the session, we would welcome that as well. Thank you, everybody.